Good morning, Mr. Murdoch. Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 16th, officers observed Lucia Forte at 6300 Antoine Drive. The officers observed the vehicle make a U-turn where there's a prohibited U-turn sign. A traffic stop was initiated. Officers had previously observed this vehicle pulling out of a known after-hours bar located at 6314 Antoine Drive, Harrison County, Texas. The defendant was a driver. Officers observed bloodshot eyes and a strong odor of alcoholic beverage. The defendant admitted to drinking 2 Bud Lights. Standard field sobriety tests were performed, 6 out of 6 HGN, 1 out of 4 one-leg stand, and 4 out of 8 walking turn. The officer observed a 12-ounce Bud Light bottle of beer that was open and about 3/4 full upon an injury.
Drinking in the car while driving.
There were also 2 unopened shooters tequila and wheel console. The defendant consented to breath. TAC came back as 0.112 and 0.109.
I missed the basis for the stop. Can you tell me that one more time?
They saw the vehicle perform a U-turn in an area where the U-turn was prohibited.
Okay. Mr. Murdoch, I'm going to find that there's probable cause to go forward with your case. I would figure that it was damn elementary that you're not to have alcohol in the car while you're driving. I am now taking away your privilege to drive. You were not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. And I don't give a rat's behind what your excuse is. There's a burning building and you have to save 50 children. Do you understand? Every time you drive, it's punishable by up to 6 months in jail and a $500 fine. Every time you drive. Can you look, see if he has any priority to the ice, please? Look, what kind of, does he have any priority to the ice, please? Okay. Mr. Murdoch, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you if I find that you're using. Likewise, I will book your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir? I'll have you fill out an application. I'll see whether you qualify. Heed this warning, Mr. Murdoch. You will not get another one. Do not become a danger to my city. All right?
Get this way.
Are you Jackson Norton? Sir. Mr. Norton, you were charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
February 15th, officers responding to 1025 West Nassa Parkway, bar Buckwild in Harrison County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. The second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it out, the second complainant grabbed the defendant, and the defendant turned around and punched him on the side of the head. The second complainant said that he believed he was unconscious for multiple seconds. When he woke up, he was laying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed the still on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small liquid bump on the end of his elbow next to his eyebrow next to his hair.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No judge.
Same set of facts, whereas alcohol as well?
The previous assault happened at a high school graduation party.
But there was alcohol?
Yes, judge, it's not like that.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
We're now working on our fourth, so I will do everything in my power to protect my public at all costs. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well. Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is protection of my city, and I'm going to do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take a seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application.
Yes, sir.
Jackson Norton, you just gave him bond conditions and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there, but his.
So what I said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance, so he can be on call and he have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. My documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I'm not going to take his word for it that he gets up at 3 in the morning or 2 in the morning to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
Okay, so we'll keep the curfew in place, and then if he needs to travel for work, we can provide proof that he's clocking in and clocking out.
No contact with any of the complaining witnesses, no weapons. And then he's got the device on his ankle, so we know he's not consuming it too.
Is that a scram? Okay. So scram and GPS is what you're doing?
No, I didn't. Yeah, I guess so that we know that he's not out in the middle of the night, and if, after some time, if he's good, then we can amend the conditions as far as the GPS.
Okay.
Scram.
30 to 60 days?
I mean, be proactive. You know what I mean? Show me, I want to know that there are not going to be any more issues, but yeah, okay. Thanks, Denise.
7 to 7?
No. I don't know. He said he had a problem with 6. I didn't know. What did I do? I didn't do 7 to 7.
Sorry, we're gonna do 9 to, the standard 9 to 6.
9 p.m. to 6 a.m.? I think he has to be at work at 6 a.m., right?
So, yesterday,
Can you
I
come
still do 5 a.m.
5 a.m.? 9 p.m. to 5 a.m.? Okay.
so this is that I work from 6 to 11 at night.
Yeah, I'll give 5 in the morning.
Thank you.
I don't want any more issues.
Like earlier, can I do like midnight? Because sometimes it's 30 minutes drive back home and I get off at
I'm
11.
not giving you till midnight. It's not going to happen. And I want proof of anything that, as far as work is, I'm not going to take your word for it. So I need proof that, that they're actually working at this time and then we can work on your schedule, but I'm not letting you out in the middle of the night. It's not going to happen.
Sir.
Okay. Thanks.
Judge,
9 to 5, Judge.
9 p.m. to 5 a.m.
9 to 5, right. Yeah.
So we're gonna amend.
Mr. Vieira, you were charged with driving while intoxicated, second offense. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 24th of 2023, officers observed a dark sedan stopped at the light traveling westbound on Washington Street. And when the light turned green, the officer began to go in the motor vehicle. A black BMW almost struck a patrol vehicle on Shepherd Drive, causing the officer to hit the brakes. The motor vehicle then proceeded to drive southbound in North Shepherd, driving down a one-way street. A traffic stop was conducted. The officers approached the vehicle and observed a mild odor of alcoholic beverage coming from the vehicle and an open liquor bottle on the floorboard behind the passenger seat. The defendant was identified as Christopher Vieira. The defendant was observed to have bloodshot eyes and slurred speech. The defendant stated that he had not been drinking and he was just driving around. As officers were conducting the walking turns, the defendant stated he had surgery on his foot/leg when he was a baby and that something was wrong with him. HGN 6 out of 6 clues, walk and turn, 5 out of 8 clues, and a 1 leg stand, 2 out of 4 clues. During an inventory search, the officers found that open Escalon tequila bottle. The DIC was red and the defendant consented. The breath results were 0.133 and 0.1.
We've had a lot of issues with Mr. Vieira. And this case is now 700 days old. Take a seat for me in the jury box. Let's wait for his lawyer to get here.
Thought that was in court 7 all
Don't worry
morning.
about it. I'm happy to have you, you know?
Mr. Vieira, who's in bond forfeiture for a long time, or? Let me see, Judge.
So you're still on it.
Yes, Judge.
I'd like you, please, because
Sure.
what I'm gonna do now is, I'm putting an ankle monitor on him.
Okay.
Come up, come up.
You mean a GPS monitor or a SCRAM device?
Oh,
Oh, okay. One for each ankle, okay.
get a curfew of 7 to 7. And then, is discovery complete? Please tell me it is. Please tell me
Double
it
check, Your
is.
Honor. Do you have a cause number by any chance? It's not coming up.
I got it right here. It's 245-1072.
There we go. Yes, it's complete, Your Honor.
You have 2 weeks to figure out what you want to do on this case. You must be back here in 2 weeks and I will either set your case for trial or you will accept a plea bargain agreement. But you have multiple bond forfeitures. You have had bond violation after bond violation after bond violation. Today, you get 2 monitors. One is a scram, so I know that you're not consuming alcohol. The other one is GPS monitor, so I can keep tabs on you. And let me express my, in the event that you ever take off on me, I will do la cucaracha on your bond. Do you understand? Do you have an offer on this case, please?
Yes, we have both a 30-day and an 18-month probation.
You're not to consume alcohol, illegal drugs. You'll be randomly tested. Does he have a Texas driver license, please?
I'm gonna run it right now to see if it's eligible.
There is already from 2023 an order for you not to drive. You are not to drive. I don't care what's going on in your life. If I find that you're driving a car, I will have a contempt hearing. You understand?
His license is suspended.
Okay. You don't have a Texas driver license. You are not allowed to drive. One ankle, you understand you'll get a scram monitor, your other ankle a GPS monitor, and I'm giving you a curfew of 7 to 7. Back here in 2 weeks, you must accept the plea bargain agreement. It is your responsibility to get with Mr. Sims. If you do not get with him, then if you have immigration issues, it's your responsibility between now and then to also see an immigration lawyer as well. Do you understand?
Yes, sir.
Okay?
Thank you,
All right,
Judge.
I'll see you in 2 weeks. You will get with Felicia for your bond conditions.
Just, do you want to have a seat in the jury
I
box?
can
Judge,
right
or-
now.
Okay.